We'll continue our discussion of agency law by talking about tort liability. First off, let's reestablish what we know. Is an agent liable when an agent commits a tort? Yes. Don't forget what we learned when we were talking about torts. Everyone is liable for their own torts. But what about the principal? Is the principal liable when the agent commits a tort? First, let's look at a couple of things. There may be direct liability. In other words, it's possible that the principal was herself negligent. For example, if the principal runs a delivery service and they hire someone to drive without checking that person's driving history or training that person on how to operate the truck or keeping the truck in good repair, all that conduct could be characterized as negligent, and the principal in one of those circumstances could be liable for their own negligence. And that would be on a theory of just direct liability for their own failure to exercise reasonable care. So both of these first two topics were covered back when you learned about torts. That's not the problem in this chapter. Here our problem is, can the principal be liable for when the principal did nothing wrong? Can the principal be liable for the agent's torts when the principal didn't do anything wrong themselves? In other words, the principal did not commit a tort. Can the principal become liable? And the answer is maybe. We're going to use the rule of respondeat superior and to say that sometimes the principal will be liable, although the principal did nothing wrong. The principal can be vicariously liable for the tort of the agent. How can that be fair? Well, first off, the public policy rationales include: who's getting the economic benefit of the conduct? Well, the principal gets the benefit of the conduct. The principal gets the benefit of that conduct, and why not have them bear the burden as well? That's the thinking. Secondly, the principal can plan both financially and in terms of their operations to bear the risk of the agent's malfeasance. So the principal can set aside reserves or carry insurance to plan financially for the possibility that an agent will commit a tort. And in terms of operations, the principal can plan for that too. They can do their best to make sure that people are well trained, that you reinforce safety standards, that you monitor people's behavior, that you make sure it is a condition of employment, that people behave safely. So employers can plan in terms of their operations. And finally, look at the world that you're creating. In general, if you are going to be liable for someone else's tort, you're going to do everything you can to reduce the risk that the agent will commit a tort. In general, this will hopefully create a safer society, because somebody is going to have to pay for this, even if that someone did not cause the tortious conduct. Let's go through the general rule. Respondeat superior says that a principal is vicariously liable for an agent's tort when, number one, there's a master-servant relationship, and number two, the tort occurred in the course and scope of employment. Well, what's a master-servant relationship? We're going to talk about that in a second, but I just want to caution you that this is the same thing as an employer-employee relationship. The terms are used synonymously in the cases. You can choose which one you prefer. It doesn't matter to me. I've had students who are really offended by the term master-servant, but honestly, I often feel like the servant, so it doesn't really bother me. What is a master-servant relationship? A master-servant relationship is one where the principal not only has the right to direct, but also to physically control the agent's conduct. In other words, the power to tell the agent not only what to do, but how to do it. They are controlling, or at least they have the right to control, the way in which the agent does his work. Sometimes this is an easy problem to solve, and sometimes it's hard. If you go to your CPA to have your tax return filed, it's clearly an independent contractor relationship and not master-servant. Your CPA is your agent for purposes of filling out your tax return. You're not controlling the way in which he does his work. You're simply directing him on what to do, not how to do it. He is your independent contractor, and you are not vicariously liable for his torts. Other cases are equally easy to solve in the other direction. You go to a restaurant and the waitress negligently spills something on the floor, doesn't clean it up, The customer slips and falls and hurts himself. Was the waitress an employee? Well, does she work regular hours? Does she wear what the employers say she has to wear? Does she serve the table the employer says she has to serve? Does she have to follow all the rules in that workplace? She looks like a servant to me. So these two examples aren't debatable, but of course the hard ones are the gray area cases where it's really not clear if that person is an employee or an independent contractor. Significant factors include continuity. Is this episodic or is it a continuous relationship? If it's continuous, it tends to look more like an employment relationship. Look at the frequency for payment of services. Is that person getting paid for completed jobs? That looks like an independent contractor. Or are they getting paid hourly or daily or weekly or monthly? That looks more like an employment relationship. Look at the duration of the relationship. The longer the relationship has lasted, the more likely it is to be an employment relationship. Look at who owns the tools, the equipment, the vehicles. Control generally follows ownership of the tools and the equipment. Look at the work site. Is it wherever the independent contractor wants to get it done, or is it a particular workplace controlled by the principal? The latter tends to look more like an employment relationship. Consider whether the agent is free to accept other work. If she is, then that tends to make her look like an independent contractor, not an employee. The agent's skill level is relevant, and generally the more highly skilled the agent, the more you would think that agent was an independent contractor. Look at the intent of the parties. How do they view it? Look at their intent as evidenced by their conduct, not necessarily simply their words. There's a lot of litigation around this topic, and you've probably seen plenty of it in the press. It involves not just the context of respondeat superior, in other words, tort liability, but also tax disputes, employment rights cases. It's often in the principal's best financial interest to characterize everybody as an independent contractor. Not only are they therefore not responsible for the person's torts, they would hope, while working, but then the employer doesn't have to pay employment-based taxes or give employee benefits or incur the other consequences of employment. So oftentimes you will have agreements in which the agent and the principal say, yes, we agree that you are an independent contractor, you are not a servant. Are these agreements binding? The general answer is no. The court is going to look at the degree of control the principal had over the agent. Courts understand that there is a lot of self-interest in characterizing a relationship one way or another. Look at customer usage in the industry, and that helps to solve the issue of how much control is going on. Now, once you have established that someone was a servant and not an independent contractor, what is the second part of the test? The second part is whether the servant was acting in the course and scope of employment at the time the tort occurred. A servant is acting within the course and scope of employment when, and this is a three-part test, number one, he was doing the type of work he was hired to do. Number two, he's at his time and place of employment. And number three, when he has the purpose of serving the master. Let's take each of these three things separately. First off, let's look at the type of work. A servant is doing the type of work he was hired to do if it was either authorized work or incidental to the authorized work. Is there a prior history of doing it, or maybe permission or instruction to do it? Is it anticipated by the master, or should have been anticipated by the master? Is it commonly done in such contexts? So this is going to pick up not just I'm hiring you to deliver packages, but anything related to the process of delivering packages. Course and scope of employment. This means the time and place of employment. Was the tort committed when and where and while the servant was working? This is a fancy way of saying, did this happen at work or not? If it didn't, then the principal, the master, is not liable. If it did, she is. We're going to have to look at where the place of employment is and when the time of employment is. Place of employment sometimes is easy to determine, sometimes not. It may be your normal job to work at a particular work site, but maybe your employer has asked you to deliver something to a client. In that case, it's possible that driving on the 405 was your place of employment at that particular moment because you were following your employer's directions on delivering some items to a customer. When is an employee working? Again, generally, the farther down on the food chain the employee is, the easier it is to tell whether or not she's working. The higher up you go in terms of management, the harder it is to tell whether someone's working. Be careful. Sometimes students, especially undergrads, will say, well, is it on the clock or not? That's not necessarily going to determine the question. A clock system is really meant for an employer to see whether someone's putting in all their hours at work. You're working if you're engaged in the activity assigned by your employer. If you just clocked out and now you negligently spill something and a client slips and falls, no court is going to say, oh, they clocked out, now they're no longer at their place or time of employment. That's not going to happen. A court instead would say, no, they are still at work. They haven't yet left the workplace. They're still working. So don't look for the easy out. Work with your judgment, apply the rules to the facts. There are some special problems with time and place of employment. Let's go through them. First off, let's take lunch hour and breaks. Let's take the easier one first, breaks. Suppose you have a coffee break at work. You're just taking a brief break from work. Is there anybody who lacks the power to bring you a work-related problem while you're doing that? No, you're kind of on a personal break, but you're kind of still working. You're still physically at the workplace. Therefore, a court will say, if it's simply a break and you're still at the location of the work, then you're still working and you're still at your time and place of employment. How about a lunch hour? If you're taking your lunch at work, again, does anyone hesitate to interrupt you if there's a problem? Not at any place I ever worked, so a court would probably say, if you're taking your lunch at the place of employment, you're still working. On the other hand, if you leave the place of employment for your personal lunch, the court would probably say, okay, they left for lunch and note they're now. On the other hand, if you leave that place of employment for your personal lunch, a court would probably say, okay, they left for lunch, now they're no longer at work, and therefore if they commit a tort, the employer is not liable because the employee wasn't working. How about if you're driving to work but you haven't yet gotten there? You negligently strike another car. Are you working? No. You're not working until you get to work, and therefore if you're going to work or coming from work, a court will generally say that you are not at your place of employment. This is sometimes called the coming and going rule. You're not at your time of employment, and therefore the master is not liable if you commit a tort. Be careful though. Every once in a while, you will find people where maybe they're not starting work at the normal place of work. Suppose, for example, that you work in a medical services office and every Friday is bagel day, and this Friday it's your turn to get bagels. You drive from home to the bagel place, and then you're going to drive from the bagel place to work. The employer has authorized bagel day. The employer pays for bagel day as part of the work. You get in an accident while driving from the bagel place to work. Did the accident occur at the time of your employment and the place of your employment? Probably yes. Really, you began work when you arrived at the bagel place because, although it's not your typical job, this Friday your job started with getting bagels. Therefore, once you got to the bagel place, you were at work during work. How about when you were driving from home to the bagel place? Well, now we're back to the coming and going rule. You haven't yet started work. So the employer will not be vicariously liable for any torts you commit for that piece of the trip. How about if you're deviating from where you are supposed to be and what you're supposed to be doing? Are you still working or not? The answer is it depends on how big the deviation was. A small deviation from what you're supposed to be doing and where and when you're supposed to be doing it is called a detour, and the court will say This small deviation is a detour. It is not significant, and therefore you are still at your time and place of employment. You are still working. And the principal is therefore liable under the doctrine of respondeat superior if the other factors have been met. On the other hand, a large deviation is called a frolic, and a court would say, you really left your place of employment, your time of employment, and your purpose of serving the master. You're off on something of your own, and therefore, while you're on your frolic, you're not working. And if you commit a tort during that period, your employer would not be vicariously liable. Let's take a couple of examples. Let's suppose that you're supposed to be delivering lab supplies for lab students throughout the Los Angeles area. You're supposed to be driving from one to another, and you're supposed to be collecting material and dropping them off and then delivering. For this day, you have an 8-hour day, and altogether your route is going to be 45 miles. At one point, you drop off some materials at one of the offices, as you're supposed to be doing, and you walk next door and get a frozen yogurt. You commit a tort. Are you at your place of employment where and when you are supposed to be? Well, not really. You were supposed to get back in the truck and keep driving, but you didn't. You deviated. Is it a big deviation or a small deviation? Well, physically it's a small deviation. You just went next door and the whole trip is 45 miles. In terms of time as well, it's a small deviation. It's an 8-hour day. You probably deviated for 20 minutes. That's a pretty small deviation. Therefore, if you commit a tort during this small deviation, the court is likely to say it's a detour. The principal, the master, remains liable if you commit a tort. And of course, remember, you're always liable for your own torts. You're simply probably a less attractive defendant than your employer is, because your employer likely has more assets. Now let's change it. Same facts. You have a 45-mile route, an 8-hour day, but you take off and go to the beach with your girlfriend for 3 hours. Have you deviated from where you're supposed to be? Yes. From when you're supposed to be there? Yes. From your purpose of serving the master? Yes. You're on a frolic. It's a pretty big deviation. 3 hours out of an 8-hour day is pretty big. A court would say that while you were on the frolic with your girlfriend at the beach, you were not working. You were not at the time and place of your employment. If you commit a tort at the beach, your employer therefore would not be liable. The point at which you get pretty close to resuming the time and place of the activity that you're supposed to be doing, a court would say, okay, now you left your frolic and you've resumed working. So you have to look at when the tort occurred. The third and final requirement for course and scope of employment, and again you have to prove all three, is did the tort occur with the servant having the purpose of serving the master? Look at whether the servant was doing something he was assigned to do, or was it just personal? And you come across some special issues with intentional torts. Usually these are not related to employment. Usually this is some sort of personal outburst, and typically an employer will not be liable for intentional torts committed by a servant. There are exceptions. The classic exception would be, let's say, a bouncer in a bar. They're supposed to get rid of drunken patrons who are causing trouble. You could argue that in a way their job does involve intentional torts against other people. So sometimes they're pushing someone around and that person could accuse them of assault or battery. And the purpose of doing it would not be personal. The purpose would have been to serve the master. So the servant's conduct then would be within the course and scope of his employment. So the servant's purpose would have been to serve the employer. So the general rule is there's no vicarious liability, no respondeat superior for intentional torts, but there are exceptions. How about if there was a purpose of serving the master, but there was also a personal purpose? What if there's a dual purpose, in other words, both personal and business related? The test then is whether the work-related purpose was significant. And by significant we mean it would have justified a trip on its own. Let me give you an example. Suppose that one day you're going to leave work and go have lunch, just personal lunch, not a business lunch. Your manager says, "Oh, you're going out. Would you mind taking the receipts to the broker?" And you say, "Sure, that's fine. I'm happy to do that." Do you have a personal purpose or a business purpose? Well, both. Would the business purpose have justified a trip on its own? In other words, taking the receipts to the broker. Is that significant enough to have justified a trip on its own? From what it sounds like, the answer would be yes. Therefore, you have a dual purpose. And if you commit a tort during that trip, a court would say, you're still at your time and place of employment with the purpose of serving the master, and Respondeat superior will apply. The third special issue is borrowed servants. Sometimes it happens that it's clear that someone is an employee, but it's not clear whose employee she is. There was a case a few years ago that is a good example of this. When the Pasadena Freeway was being built, there was a general contractor who had a particular piece of equipment and an employee trained to use that particular piece of equipment as a specialization. A subcontractor needed someone who had that equipment and someone who knew how to use it. So the subcontractor entered into an agreement with the general contractor in which they were going to borrow. So the subcontractor entered an agreement with the general contractor in which they were going to borrow that employee and the equipment for a 6-month period while they finished their portion of the work on the freeway. During that period, the servant negligently operated the equipment and actually killed someone. Who's liable for the tort aside from the servant? In other words, who was the master at the time the tort occurred? The question you have to answer is, who had a greater degree of control? Courts are always looking at control, or the right to control. And the answer in this case is not completely clear. For example, in this case, the general contractor owned the equipment. He had trained the employee to work with that equipment. They were still paying that employee, and they still maintained the equipment. So that's a fair amount of control. On the other hand, the subcontractor, for a pretty long period of time, 6 months, was on site when that person was working and was able to tell them what to do. And that's a fair amount of control. If you get a case like that that really falls in a gray area, then just be able to see both arguments and reach a conclusion that seems like it's stronger. Again, the test is which of the two principles had a greater degree of control over the way the agent did his work. And in the context of the real world and how to manage risk, realize this problem of borrowed servants and plan for it in terms of management and insurance. Another problem is torts committed by independent contractors. Is the principal liable for such torts? The general answer is no, because, go back to our original rule, a principal is liable if there's a master-servant relationship and the tort occurred in the course and scope of employment. Well, this one falls apart. An independent contractor is not a servant. And why should the principal be liable when the principal doesn't have the ability to control physically the way that the agent does her work? And since I gave you that rule, now I have to give you some exceptions. There are 2 exceptions we need to know for our purposes. The first involves non-delegable duties. A non-delegable duties is a duty that you are not allowed to delegate to someone else. You still have a duty to make sure it was done safely, even if you hire an independent contractor to do it. And the simplest and most common example of that would be a landowner. Suppose you own an apartment building and there's a broken step and you hire a carpenter to come fix that step, and the carpenter negligently does a bad job of fixing the step. A tenant falls and is injured on the broken step. When the tenant sues you, the apartment owner, for negligence, you're going to say, wait a second, there's no respondeat superior. I didn't fix it. I hired an independent contractor. Go sue the carpenter. Certainly the tenant can do that and will do that, I assume, but are you the landowner? Are you liable for that? The answer is yes, you are. Why? Because you have a non-delegable duty as a property owner to maintain the property in good repair, and you're liable anyway, even though you hired an independent contractor. The second category we need to look at involves ultra-hazardous or inherently dangerous activities. Please be extremely conservative as you look at this exception to the general rule. There are some activities which, no matter how safely you try to do them, cannot be done with a reasonable amount of safety. Here's an example. A few years ago, there was a construction project, and they were digging, and they shored up a trench where they were digging. And unfortunately, they did a bad job of bracing the ditch, and it collapsed and killed one of the men who was working there. Is that an inherently dangerous activity? No, an inherently dangerous activity is one which cannot be done with reasonable safety. Is it possible with reasonable safety to dig ditches and to shore them up so that they don't collapse? Sure, it happens every day that it's done safely. It wasn't safe the way they did it on that day, but that doesn't make it inherently dangerous. An inherently dangerous activity is one which cannot be done safely. So be extremely conservative. The only reported cases of which I'm aware typically fall in this category include using explosives in highly populated areas, crop dusting because you have to fly those planes so low it's really unsafe no matter how safely you're flying. Again, they'll be extremely conservative in using this exception to the general rule. Courts rarely find that the circumstances fit. Now let's discuss a couple of special problems and tie all this up. Remember when we were talking about misrepresentation and fraud? They sound in both tort and contract. You can sue for misrepresentation both in tort or in contract. You could get damages under tort law, or you could get rescission or reformation of a contract. So, which vicarious liability rules do you use? Do you use the contract rules, whether there was an agent who had authority, or do you use the tort rules? In other words, respondeat superior. The answer is the former. Use the contract-based rules. Why? Because respondeat superior has to do with physical conduct, and misrepresentation or fraud has to do with words. Representations that are oral or in writing, and it simply fits the rules better. So if you get a case of misrepresentation or fraud, use the contract rules to determine vicarious liability, i.e., was there an agent? Did the agent have authority? Do not use respondeat superior. How about torts committed by subagents? We didn't spend time on this topic because people get really confused and it's not that important. A subagent is simply an agent's agent. What happens when that person commits a tort? The test is going to be who had the right to control the way that subagent did the work at the time the tort occurred. Well, then that person's going to be the master, and that person's going to be vicariously liable for the tort. So, for example, let's pretend that you were never my student. You just come to me for legal advice. Do you and I have an agency relationship? Yes, I have agreed to act for your benefit under your direction. Am I your servant? No, you don't control physically the way I do anything. Now, let's say that with regard to your legal problem, I have hired someone to go out and serve the complaint on the defendant. And while doing that, the person I hired commits a tort. Who's liable for that tort? Well, assuming that person was a servant, they must have been my servant. They couldn't have been your servant. You didn't hire them. You didn't control them. So who is going to be liable under respondeat superior? I will. So the test is, who had the right to control what that person was doing at the time of the tort? Please don't come to me and say, I don't know, this person worked for that person. Does that make him a subagent? The general answer is it doesn't matter. Focus on what matters. You can't find any large organizations or businesses or government entities or any other enterprises where there are not a whole series of people in any command chain working under the direction of somebody else. So don't get flipped out by this. Okay, the third special problem is criminal liability. In general, there is no vicarious liability for crime. Let's suppose that you are Tony Soprano and you tell one of your little underlings to go out and kill somebody. Are you vicariously liable for that crime, Tony? No, you are not, because that crime requires particular state of mind, or in Latin, mens rea, and conduct that you didn't directly commit. You, Tony Soprano, might be liable for some different crime, like conspiracy to commit a murder, but you did not directly murder anybody. So the general answer is there is no vicarious liability for criminal conduct. Of course, there's an exception, and the exception is that there are some regulatory crimes that don't fit traditional criminal conduct. They're sometimes called strict liability crimes. They don't require any particular state of mind. The most common example would be environmental crime, like dumping hazardous waste. It is possible then that there could be vicarious liability because it doesn't require any particular state of mind. It's a regulatory law. But this is a small minority of all crimes. The general rule is no vicarious liability for criminal conduct.